and welcome to another video lecture for Mr. Mosier's 8th grade American history class. Today we're going to be looking at the Bill of Rights, your shield against the abuses of government. The amendments today we're going to be looking at are Amendments 3 and 4, so let's get started. The textbook readings for today are, again, Chapter 6, Section 2, the Bill of Rights, pages 216 to 221. Our guiding questions today are, what are your rights under the Third Amendment? What are your rights under the Fourth Amendment? What is a warrant? And how is this different at school than you might be out in the public? So let's look here at the Third Amendment. The Third Amendment reads, "No soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law." So what does this basically mean? Well, it means citizens cannot be forced to house and feed the soldiers. This might sound like a little bit of a strange right we have under the Bill of Rights, especially the fact that this is the third one listed in the Bill of Rights. But this really goes back to the time period leading up to the American Revolutionary War and that dastardly, dirty Quartering Act. Remember, the Quartering Act was a law passed by the British Parliament that forced the American colonists to house and feed the British regular troops. The American colonists hated that law. It was such an inconvenience. And so when the writers of the Bill of Rights were putting them together, they wanted to make sure that this kind of intrusion by the military soldiers wouldn't necessarily happen ever again. So the Third Amendment is kind of a testimony back to one of the biggest complaints leading up to the American Revolutionary War, those darn redcoats coming in and sleeping in my bed. And that's the Third Amendment. Today it doesn't really mean as much to us, but back then it was really important to the colonists. Let's talk about the Fourth Amendment here next. The Fourth Amendment reads, and it's kind of a long one, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." It's kind of a long one. So what does this basically mean? It basically means it guarantees citizens' right to privacy for themselves, their homes, and their personal property, and that no unjustified searches or seizures, and a seizure is a taking of your stuff, can take place by the federal government. So this is a privacy protection from the federal government that protects your privacy from the federal government, and that it requires a few key pieces. So break this down just a little bit. It protects you. It protects your homes, it protects your papers, it protects your effects, your belongings, your stuff from unreasonable, and that's a very important word, unreasonable searches and seizures. In most cases, the government, in order to search or seize your stuff, have to have a warrant, and that warrant has to be issued from a judge after hearing evidence of some suspicion of some kind of crime. Who's this protecting? You. From whom is it protecting you? From government officials. This goes back to the Revolutionary War, when British soldiers and British custom officials would raid colonial homes looking for contraband. And they would just storm into people's homes looking for evidence of some particular crimes that they could maybe pin on the colonists. The colonists wanted to make sure, the Americans wanted to make sure, remembering this intrusion of their privacy, that this would not happen again. That government would have to have some kind of legitimate reason to basically search. How does this relate to you in school stems from a story in a very famous court case known as New Jersey versus TLO. So let me read you the story about TLO. In 1980, a 14-year-old girl known as TLO was caught smoking cigarettes in her New Jersey school bathroom. In the principal's office, she denied the charge. An assistant principal searched her purse and found cigarettes, as well as marijuana, rolling papers, and lists with names on it. With this evidence that TLO was dealing drugs, authorities suspended her. Now, were her rights violated? We'll come back to this here in just a second. The courts have basically looked at that we as citizens have certain levels and expectations of privacy from our government. Now, there's kind of a continuum of some degrees of privacy where you have probably the most amount of privacy is obviously going to be in your home, your bathroom, and your bedroom. But as you move a little bit further from your place of residency, where you're the most needing your most privacy, there's a little bit of a lower level of expectation. This is why in some places, to provide for security, there are bag checks, security checks. Think of things like going into a stadium or into an airport. Your expectation of privacy is a little bit lower. Now, in most cases, in order to search you, law enforcement officials, the police, must have a warrant, but not always in all cases. The courts have ruled that law enforcement can use a standard known as probable cause. There are 7 examples of probable causes of law enforcement. One might be plain view. They see an actual illegal item that you have with you, and it's in plain view, and they can arrest you for it. Or there is an incident to an arrest involving a crime. If you are arrested for a separate crime and you get patted down, and this is to protect the security of the law enforcement officer, and they happen to find other illegal items in your possession as you're being patted down in an arrest, that also can be admissible in a court. Consent, if you just tell the officer, you can search me, they don't need a warrant. Inevitable discovery, fleeting target, Terry stop and frisk, and exigent circumstances are some of the other ones as well. Not much is used with those, but they are other possibilities with needing a warrant. Let's go back and talk about that TLO girl and see, was her Fourth Amendment right to privacy violated from the school district? The case of TLO, and her name has never been released to the public, did reach the Supreme Court in 1985. Once again, the verdict about whether her rights as a student had been violated was mixed. Students are protected by the Fourth Amendment, ruled the court in this instance. The first time the Supreme Court had ever affirmed that authorities can't search everyone. They must have an individualized suspicion that someone in particular has broken a law. But searches without a warrant by school officials are still permissible. Against the child's interest in privacy must set the substantial interest of teachers and administrators in maintaining discipline in the classroom and on school grounds. In other words, the school sitting kind of dilutes the rights of privacy because our job as school officials is provide a safe place for students and teachers to learn. And that issue of safety gives us as school officials a little bit more flexibility in terms of searching. The Fourth Amendment says in terms of school, instead of probable cause, all the school really needs are reasonable grounds, a much looser requirement than outside of school. In TLO's cases, the Supreme Court decided that the assistant principal's search of the purse was actually reasonable. He had been looking for evidence to support the charge of smoking in the bathroom. Once the search was underway, anything else that the principal found in that student's purse was justified. With this ruling, the Supreme Court overruled a lower court that had called the search not reasonable. So students under the Fourth Amendment continue to be really controversial. Are lockers at school protected from warrantless searches? Are desks? Are bodies, as they use in metal detectors, prevent weapons from entering school building? How about students' cell phones? All of these things are important questions that schools and the courts have to kind of address and see, is there a reasonable suspicion that this particular student individual is a risk not only to themselves, but also to other students? And under that grounds, the courts have given schools a little bit more leeway to search students' belongings. But that being said, you still have a protection of privacy. Schools have to have at least a reasonable suspicion. They can't necessarily just search randomly. There has to be a reason for it. So this has been Mr. Mosier looking at the Third and Fourth Amendment. The Third Amendment saying you cannot be forced to house soldiers in your home. So you're lucky you get to sleep in your bed tonight, not a soldier. And the fourth one deals with unreasonable searches and seizures. This idea of privacy from the government, that you are protected, your privacy is protected from the government from searching or seizing your belongings. But again, the key word there is unreasonable. If they have a warrant, in most cases there's a reason behind getting that warrant issued, and they can search or seize your belongings. And at school, there's a lower threshold. Schools just need what's known as reasonable suspicion, a concern that you might be a threat to yourself or others, and under that reasonable suspicion, school officials can search students' belongings. Thanks for listening. As always, if you have questions, please make sure you come talk to your teacher.